Gun laws in California regulate the sale, possession, and use of firearms and ammunition in the state of California in the United States. The gun laws of California are some of the most restrictive in the United States. A handgun safety certificate, obtained by passing a written test, is required for handgun purchases, although there are exemptions to this requirement. Handguns sold by dealers must be California legal by being listed on the state's roster of handguns certified for sale. This roster, which requires handgun manufacturers to pay a fee and submit specific models for safety testing, has become progressively more stringent over time and is currently the subject of a federal civil rights lawsuit on the basis that it is a de facto ban on new handgun models. Private sales of firearms must be done through a licensed dealer. All firearm sales are recorded by the state, and have a 10-day waiting period. Unlike most other states, California has no provision in its state constitution that explicitly guarantees an individual right to keep and bear arms. The California Supreme Court has maintained that most of California's restrictive gun laws are constitutional based on the fact that the state's constitution does not explicitly guarantee private citizens the right to purchase, possess, or carry firearms. However, recent U.S. Supreme Court decisions of Heller and McDonald established that the Second Amendment applies to all states within the Union, and many of California's gun laws are now being challenged in the federal courts. Semi-automatic firearms that the state has classified as assault weapons, .50 BMG caliber rifles, and magazines that can hold more than 10 rounds of ammunition may not be sold in California. Possession of automatic firearms, and of short-barreled shotguns and rifles, is generally prohibited. California is a may-issue state for permits to carry concealed guns. The willingness of issuing authorities in California ranges from no issue in most urban areas to shall issue in rural counties. Additionally, the issuing authority can also impose restrictions on the CCW permit holder, such as limiting concealed carry only to the purposes listed on the approved CCW permit application. However, concealed carry permits are valid statewide, regardless of where they were issued. This creates a situation where residents in presumptively no-issue locations such as Los Angeles and San Francisco cannot lawfully carry a concealed firearm, but residents from other counties with more permissive CCW issuance policies can lawfully carry within these same jurisdictions. California does not recognize concealed carry permits issued by other states, and non-residents are generally forbidden from obtaining a California concealed carry permit. California has state preemption for many, but not all, firearms laws. Actual enforcement of California's firearms laws also varies widely across the state. Urban areas, such as the San Francisco and Los Angeles metropolitan areas, strictly enforce firearms laws, and some communities within these areas have passed local ordinances that make legally owning a firearm difficult. Meanwhile, some rural jurisdictions narrowly enforce the same firearms laws by prosecuting only those who demonstrate malicious intent, or not enforcing portions of the state's firearms laws at all. Summary table: Preemption. California law restricts county and city authorities from enacting firearm regulations. This provides for uniform firearm laws and prevents situations found in other states where traveling with an otherwise legal firearm could put a citizen at risk of violating local city ordinances. Because of their inability to regulate firearms directly, some cities, such as Los Angeles, have enacted ammunition regulations. Firearm sales. The buyer of a firearm must fill out an application to purchase a particular gun. The firearms dealer sends the application to the California Department of Justice, which performs a background check on the buyer. The approved application is valid for 10 days. There is a 10-day waiting period for the delivery of any firearm. Sales of firearms from one person to another must be through a licensed firearms dealer using a private party transfer form. The licensed dealer may charge a $10 fee, in addition to the $25 transfer fee that the state charges. Any number of firearms may be transferred at one time using this method. The dealer submits a dealer's record of sale form to the state, and the purchaser must wait 10 days before picking up the guns. Federally defined curio or relic long guns over 50 years old may be sold without going through a licensed dealer. Handgun purchases, except for private party transfers and certificate of eligibility holders, are limited to one per 30-day period. To purchase a handgun, a buyer must have a handgun safety certificate. This is obtained by passing a written test, given by a Department of Justice certified instructor, on the safe and legal use of handguns. The certificate is valid for 5 years. A buyer must also perform a safe handling demonstration when taking possession of a handgun. Some individuals are exempt from the safety certificate and handling demonstration requirements, including active and retired military and law enforcement personnel, hunter safety certificate holders, and concealed carry license holders. Roster of handguns certified for sale. Dealers may not sell any new handgun unless it is listed in the State Department of Justice roster of handguns certified for sale. Listed handguns must include certain mechanical features and pass a set of laboratory tests. Private party transfers, curio relic handguns, certain single-action revolvers, and pawn consignment returns are exempt from this requirement. Microstamping. On May 17, 2013, the state began enforcing a new law requiring that semi-automatic pistols incorporate microstamping. With this technology, very small markings are engraved, using a laser, on the tip of the firing pin and on the breech face of the firearm. When the gun is fired, these etchings may be transferred to the primer by the firing pin, and to the cartridge case head by the breech face, using the pressure created when a round is fired. If successful, this imprints two identifying numbers, unique to that gun, on each spent cartridge casing. This requirement applies to new guns being added to the California Department of Justice's roster of handguns certified for sale. Semi-automatic handgun models already listed on the roster are not required to incorporate microstamping. Concealed carry. California is a may-issue state for concealed carry. A license to carry a concealed firearm may be issued or denied to qualified applicants at the discretion of the county councils or city attorneys and their place of residence. In practice, the attitudes of different sheriffs and police chiefs toward the issuance of permits vary widely and, consequentially, different jurisdictions in California can vary anywhere from de facto shall issue to de facto no issue. A permit may be issued, by a county sheriff or city chief or head of municipal police, in one of two formats: a license to carry concealed a pistol, revolver, or other firearm capable of being concealed upon the person. Where the population of the county is less than 200,000 persons according to the most recent federal decennial census, a license to carry loaded and exposed in that county a pistol, revolver, or other firearm capable of being concealed upon the person. California does not recognize any concealed carry permits issued by other states or their political subdivisions. With exceptions for non-resident active duty military members permanently stationed within California, state law generally forbids non-residents from obtaining a California CCW permit. California law provides that the sheriff of a county or a city police chief may issue a license to carry a concealed weapon upon proof that the person applying is of good moral character and that good cause exists for the issuance. While it is generally believed to be extremely difficult to obtain a license to carry a concealed weapon in California, the difficulty varies greatly by city and county of residence. In some rural counties, qualified applicants are usually successful in obtaining a license, while some cities and counties, such as San Francisco and Los Angeles, are extremely restrictive in what they perceive to be good cause, such as a clear and immediate threat on the applicant's life that cannot be avoided or mitigated by other means. Some jurisdictions have established additional local requirements the applicant must meet before the issuing authority grants a CCW permit. For example, Monterey County requires applicants to obtain a mental health assessment at the applicant's expense as part of that county's permit application process. That particular county will typically grant CCW permits to individuals who have a clean mental health assessment, pass a background check and complete the required firearms safety training. In some of the more restrictive cities and counties, licenses tend to be issued mainly to friends of the sheriff, celebrities and campaign donors. Some of these departments are now being challenged in federal lawsuits, under the Equal Protection Clause of the 14th Amendment. Some argue that the California system for CCW issuance fosters systematic discrimination of applicants, as it has been publicized that numerous celebrities and government officials have been issued CCW licenses in cities and counties where the general public have been consistently denied. CCW issuance is also extremely low in areas where the population has a high concentration of minorities, and minority applicants are more frequently denied, causing some to allege institutional racism. Carrying a concealed firearm without a permit is a very serious misdemeanor with a minimum penalty of 90 days in jail. It may be prosecuted as a felony if any one of over a dozen specific circumstances exist, such as carry by a felon, carry in relation to gang activity, carry with the intent to commit a violent crime, etc. Perita v. San Diego, on February 13, 2014, a three-judge panel of a federal appeals court, in the case of Perita v. San Diego, ruled that California's may issue concealed carry rules as implemented by the County of San Diego, in combination with its ban on open carry in most areas of the state, violate the Second Amendment, because they together deny law-abiding citizens the right to bear arms in public for the lawful purpose of self-defense. The San Diego County Sheriff's Department issued a press release dated February 21, 2014 stating it will not seek review of the decision by the entire membership of judges sitting in the Ninth Circuit, and should the decision of the Ninth Circuit become final, the Sheriff's Department will begin to issue CCWs in situations where the applicant has met all other lawful qualifications and has requested a CCW for purposes of self-defense. This paves the way for California's may issue law to be replaced with a shall issue law. On February 27, 2014, California Attorney General Kamala Harris filed a petition for en banc review of the decision. As the state was not a formal party of the case, her action is not an appeal, but merely a request that the full court rehear the case en banc on its own initiative. However, the petition filed was denied by the Ninth Circuit on November 12, 2014. Open carry of loaded or unloaded firearms in public is generally prohibited, although open carry may be allowed in unincorporated rural areas under certain circumstances. Personal possession of a loaded firearm is prohibited in incorporated areas or prohibited areas of unincorporated territory without a license to carry or other exemption provided for by law. A license to carry loaded and exposed may be issued by a police chief or county sheriff in a county with population of less than 200,000 persons at the last census. No license or permit is required to openly carry a loaded firearm in unincorporated areas where discharge is not prohibited by local ordinance. Carrying a loaded magazine separate from the handgun is also not prohibited under the Penal Code of California. Penal Code A Section 12031 defines what constitutes a loaded weapon. In the case of People v. Clark, a shotgun shell attached to the shotgun, although not chambered or placed in a position where it was able to be fired, was declared to be legal under California law, and the charge of having a loaded firearm against Clark was dismissed. Prior to January 1, 2012, it was legal to openly carry an unloaded handgun in public. In October 2011, Governor Jerry Brown signed a bill that modifies the law on openly carrying an unloaded firearm to match the restrictions for openly carrying a loaded weapon. Legislation was later signed by Governor Brown to expand these restrictions to long guns and shotguns. Transportation. When being transported, handguns must be unloaded and in a locked, fully enclosed container rather than the glove box or any console attached to the vehicle. The trunk of a car is considered to be a locked container, but a glove box or utility box is specifically forbidden. If one believes he or she is within a gun-free school zone, then the handgun must be locked in a fully enclosed container. Failure to lock up a handgun while in a school zone is a violation of federal and state law. Long guns must be unloaded when transported in a vehicle. There is no requirement for a locked container with the exception of long guns considered to be assault weapons. Federal law requires locking containers when inside of a gun-free school zone. The constitutionality of the Federal Gun-Free School Zone Act is in question due to the U.S. v. Lopez ruling. Assault weapons. as defined by California law, must always be transported in locked containers and may only be transported under certain circumstances, traveling into California for purposes of competition, PCA Section 30665. Possession and importation of assault weapon or .50 BMG rifle interstate by non-resident. Conditions permitting Sections 30,600, 30,605, and 30,610 shall not apply to the possession and importation of an assault weapon or a .50 BMG rifle into this state by a non-resident if all of the following conditions are met. The person is attending or going directly to or coming directly from an organized competitive match or league competition that involves the use of an assault weapon or a .50 BMG rifle. The competition or match is conducted on the premises of one of the following: a target range that holds a regulatory or business license for the purpose of practicing shooting at the target range. A target range of a public or private club or organization that is organized for the purpose of practicing shooting at targets. The match or competition is sponsored by, conducted under the auspices of, or approved by, a law enforcement agency or a nationally or state-recognized entity that fosters proficiency in, or promotes education about, firearms. The assault weapon or .50 BMG rifle is transported in accordance with Section 25,610 or Article 3 of Chapter 2 of Division 5. The person is 18 years of age or over and is not in a class of persons prohibited from possessing firearms by virtue of Chapter 2 or Chapter 3 of Division 9 of this Code or Section 8100 or 8103 of the Welfare and Institutions Code. Child safety. Firearms must be kept locked up when children may be present. The 2008 California Dangerous Weapons Control Law modified California Penal Code A Section 12,035 defining criminal storage of a firearm as keeping any loaded firearm within any premises that are under his or her custody or control, and he or she knows or reasonably should know that a child is likely to gain access to the firearm. A person may be charged with a crime if he or she keeps a loaded firearm, and the child takes the firearm to a public place or causes injury. Assault weapons. Since 1989, it is illegal to sell a firearm that the state has defined as an assault weapon and that has been listed in the California Department of Justice roster of prohibited firearms. This includes many military look-alike semi-automatic rifles and .50 caliber BMG rifles. DOJ roster firearms may be legally possessed if registered with the state prior to January 2005. Military look-alike firearms that are not listed on the DOJ roster of prohibited firearms, known as off-list lowers, are legal to own and possess as long as state laws concerning configuration are followed. It is illegal to import, sell, give, trade, or lend a magazine that holds more than 10 rounds of ammunition, except for fixed tubular magazines for lever-action rifles and .22 caliber rifles. However, the possession of such magazines is legal. It is illegal to possess an automatic firearm or a short-barreled shotgun or rifle without permission from the DOJ. Such permission is generally not granted. Enforcement of the ban varies throughout the state. Authorities in most urban areas will prosecute someone for merely possessing a prohibited firearm regardless of intent, whereas county sheriffs and local police in some rural counties have either refused to enforce the ban or to only prosecute those in possession of banned weapons who demonstrate malicious intent. The California Highway Patrol strictly enforces the ban and will arrest anyone regardless of where in the state the violation occurs. Assault Weapons Control Act of 1989. The Robert E. Rose Assault Weapons Control Act of 1989, its augmentation in 1999, and the .50 caliber BMG Regulation Act of 2004 have led to many restrictions on semi-automatic firearms. In addition to a list of specific firearms that are banned by name, the following firearms are banned by characteristic: 1. A semi-automatic, centerfire rifle that has the capacity to accept a detachable magazine and any one of the following: A pistol grip that protrudes conspicuously beneath the action of the weapon. B. A thumbhole stock. C. A folding or telescoping stock. D. A grenade launcher or flare launcher. E. A flash suppressor. F. A forward pistol grip. 2. A semi-automatic, centerfire rifle that has a fixed magazine with the capacity to accept more than 10 rounds. 3. A semi-automatic, centerfire rifle that has an overall length of less than 30 inches, 762 mm. 4. A semi-automatic pistol that has the capacity to accept a detachable magazine and any one of the following: A. A threaded barrel, capable of accepting a flash suppressor, forward hand grip. B. A second hand grip. C. A shroud that is attached to, or partially or completely encircles, the barrel that allows the bearer to fire the weapon without burning his or her hand, except a slide that encloses the barrel. D. The capacity to accept a detachable magazine at some location outside of the pistol grip. 5. A semi-automatic pistol with a fixed magazine that has the capacity to accept more than 10 rounds. 6. A semi-automatic shotgun that has both of the following: A. A folding or telescoping stock. B. A pistol grip that protrudes conspicuously beneath the action of the weapon, thumbhole stock, or vertical hand grip. 7. A semi-automatic shotgun that has the ability to accept a detachable magazine. 8. Any shotgun with a revolving cylinder. In addition, bans, by definition, short-barreled shotguns and short-barreled rifles. Defined in Penal Code A Section 12020. A short-barreled shotgun is defined as a firearm to fire a fixed shotgun shell and has a barrel or barrels of less than 18 inches or an overall length of less than 26 inches. A short-barreled rifle is defined as a semi-automatic, center-fire rifle with a barrel length of less than 16 inches or an overall length of less than 26 inches. Bullet button. Methods of obtaining particular styles of firearms similar to assault weapons have been achieved by design changes by gun parts manufacturers to allow a person to obtain a style of rifle used in sport shooting and competitions. One of the most common modifications is a bullet button, which modifies a rifle so that the magazine is not removable without the use of a tool, which presses a button that a finger alone cannot press. Weapons with this feature no longer have a detachable magazine within the assault weapons definition, and therefore may be exempt depending on the other requirements. As certain portions of firearms are banned by model name under California state law, multiple requirements are made to allow a rifle to comply under state law. Exceptions: California's assault weapons ban has a provision for an individual to seek approval from the state DOJ to acquire, transport and possess a firearm that meets the state's prohibited firearm criteria, although such approval is generally not granted unless the applicant qualifies under a limited set of exceptions. Individuals who owned listed assault weapons before the 1989 assault weapons ban went into effect are allowed to keep such firearms. Owners were required to register such weapons with the California DOJ by a deadline established in the assault weapons ban legislation. Non-resident, active duty military members who bring their firearms into California when permanently assigned to a military installation within the state. Prior to arrival, the military member must submit a registration form and a copy of his or her assignment orders and an authorization letter from the installation commander to the DOJ, and the firearms in question are legal to obtain and possess in his or her home state. Resident police officers in California may own listed assault weapons with permission of their police chief and the DOJ. As of 2011, police officers may keep their assault weapons and high-capacity magazines after retirement or separation from the force. No permission is needed for police to purchase and possess magazines that hold more than 10 rounds of ammunition, but they must present proof of their active law enforcement affiliation. Firearms that would have been classified as assault weapons but are used for Olympic and international competitions are exempt. There is a list of the exempt firearms, and new firearms can be added to the list if needed by USA Shooting, the governing body for Olympic and international shooting sport competition. Assault weapons being imported into California for sale and delivery to a federal, state or local governmental agency for use by employees of such agencies to perform official duties. Assault weapons intended for use in the film industry are allowed, with approval from the DOJ. Non-residents transporting assault weapons through California, There are protections under the Federal Firearm Owners Protection Act for non-residents traveling through California with firearms that meet the state's assault weapon criteria. First, the weapon must be legal for the traveler to own under federal law and under the laws of his or her home state and the state of destination. Additionally, the weapon in question must be unloaded with the firearm and ammunition locked in separate cases and placed in an area of the vehicle that is not easily accessible, such as the trunk of a car or bed of a truck. Finally, the traveler should traverse the state by the shortest route and make the minimum number of stops practicable. Other laws. There are also numerous other laws, such as prohibition on possession of tracer ammunition, handgun armor-piercing ammunition, .50 BMG rifles, and the sale or transfer of magazines with a capacity of more than 10 rounds. All rifles are normally exempt for the original owner if properly registered at the time of the acts which prohibited them. In addition, the law states that any weapon that is part of the AR-15 series or AK series is also an assault weapon, regardless of manufacturer. This dates back to 1989 ban, and was confirmed in the Kaisler v. Lockyer decision, filed 62,000. However, the California Supreme Court declared the identification of assault weapon by series membership to be too dubious and difficult for the average citizen or even trial court to make without specific and clear model identification guidelines. The court thus set some specific requirements for the series identification portion of the law in their ruling of Harrod v. County of Kings, filed 62,001. This decision required banned firearms to be specifically listed by make and model in California Code of Regulations. It did not address assault weapons defined by features. Thus, only firearms specifically listed by exact combination of manufacturer and model name, or conforming to explicit exterior characteristics can be banned under current legislation. Once it was realized the California Department of Justice had not updated the Kaisler list in the 5 years after the Harrod decision, many Californians found they could legally purchase and possess AR and AK rifles not yet officially identified as series members. As of February 2006, over 10,000 off-list receivers for such rifles have been legally imported to, and purchased within, California. The only requirement for these receivers are that the combination of make and model is not explicitly listed as banned, and as long as the owner does not add certain characteristic features turning the firearm into an assault weapon. These characteristic features can be used, however, if a non-detachable 10-round magazine, conforming in the converse to the California Code of Regulations A Section 5469, formerly A Section 978.20, definition of detachable magazine, is affixed to such off-list rifles. These off-list rifles can also be used without a pistol grip, folding stock or flash hider, in which case it is legal to own and use them with detachable magazines. The CADOJ produced a report from the Ferranto Commission in response, intimating that this list will be updated in early 2006. As of December 2006, it had not done so. On February 1, 2006, the CADOJ also issued a controversial memorandum about this subject. Critics say the described actions are not founded or supported within statutory law in Penal Code a millisecond section 12,275 Euro 12,290. This memo stated that once off-list series firearms are declared and registered as assault weapons, they will not be able to have characteristic features added or fixed magazines removed. This is being challenged by pro-gun groups, since there is no criminal violation in the California Penal Code for adding or changing features to a legally acquired, registered assault weapon. On November 8, 2005, San Francisco voters enacted Proposition H, a total ban on the manufacture, sale, transfer or distribution of firearms or ammunition in San Francisco, as well as a ban on the possession of handguns within the city by San Francisco residents. The ban did not prohibit possession of weapons other than handguns, nor did it prohibit residents of other cities from possessing handguns in San Francisco. While this measure made San Francisco the third major U.S. city, following Washington, D.C. and Chicago, to enact a ban on handguns, San Francisco's ban extended further, not implementing a grandfather clause found in Chicago's and Washington, D.C.'s laws that protected existing gun owners. Proposition H stated that handgun owners in San Francisco must turn over their handguns to the police by the end of March 2006, have them confiscated, or move outside the city limits. In June 2006, Judge James Warren of the San Francisco County Superior Court struck down Proposition H, asserting that under California law local officials do not have the authority to ban handgun ownership by law-abiding citizens. On January 9, 2008, a California appellate court upheld Judge Warren's decision. The National Rifle Association opposed the ban from its inception. In May 2013, the Los Angeles City Council voted to draft a law prohibiting the possession of large-capacity ammunition magazines, sparking lawsuit threats from two gun rights organizations. In November of the same year, the city of Sunnyvale passed a similar ordinance along with 3 other firearm-related restrictions. The new ordinance requires city residents to dispose, donate, or sell any magazine capable of holding more than 10 rounds within a prescribed period of time once the measure took effect. Measure C also requires, 1. City residents to report firearm theft to the police within 48 hours, 2. Residents to lock up their guns at home, and 3. Gun dealers to keep logs of ammunition sales. The city of San Francisco then passed similar ordinances a short time later. SB 199 passed in August 2014 requires all fake guns to be painted in bright colors for safety reasons. Bill 1014 that has passed the state Senate in September 2014 would allow the police to confiscate guns from high-risk individuals for a period of 21 days. On September 30, 2014, Governor Brown signed the law which is phased in through January 1, 2016. See also, Guy Montagdo v. San Francisco Housing Authority, Law of California, Mulford Act, Perita v. San Diego, Robert E. Rose Assault Weapons Control Act of 1989, San Francisco Proposition H, References. External links, calguns.net, California DOJ Bureau of Firearms page, California DOJ, California Firearms Laws Summary Booklet, Legal Community Against Violence California State Law Summary, the Cal Guns Foundation, Cal Guns Foundation Wiki.